Welcome to episode 54 on the Law Report. Today we are going to deal with strict liability offences in criminal cases. And you would have remembered or should remember that in episode 53 I dealt with the issue of intention, and I told you that intention is the mens rea or the guilty mind, and that there are different categories of mens rea. Intention itself, which is subdivided into other subcategories, plus recklessness and negligence. Well, today we are going to look at strict liability offences, and strict liability offences are offences that do not require a mens rea or a guilty mind for the offense to be committed. But before I do so, my usual disclaimer: this is not legal advice, should not be construed as legal advice. For legal advice, please contact an attorney of your choice. Strict liability offenses or strict liability crimes are crimes which require no proof of mens rea or the state of mind of the person who allegedly commits the offense. Strict liability offenses are primarily regulated offenses aimed at businesses in relation to health and safety or the environment. Also, many driving offenses in criminal law or strict liability offenses. Example: speeding, driving without insurance, etc. The use of strict liability offenses in criminal law is controversial because a person may be liable where they are not at fault, or where they have taken all reasonable care or all reasonable steps to ensure compliance with the law. A typical example is in the case of Callow and Tilstone that was decided in 1900. In this case, a butcher was convicted of selling unfit meat even though he had the meat certified as safe by a vet before it went on sale. His conviction was upheld as the offense was one of strict liability, and it mattered not how diligent he had been to ensure the safety of the meat. That may be unfair, but it is how the law of strict liability operates. A person may have a very good reason for driving a motor vehicle without a license. Maybe an emergency, we don't know, but he would still be guilty of driving an unlicensed vehicle. The harshness of strict liability in criminal law is generally tolerated because it brings practical benefits to society and provides a great level of protection to the public in areas where it is perceived that there is need for such protection. A strict liability has the potential to create injustice and to operate harshly. There is a general presumption that the mens rea is required before criminal liability could be imposed. In the case of Gammon, Hong Kong Limited, and the Attorney General of Hong Kong of 1985, it states that this presumption, the presumption of the proof of mens rea in criminal cases, could be rebutted in 4 instances. Number 1, if the crime is regulated as opposed to a true crime. 2, if the crime is one of social concern. 3, if the wording of the act or the ordinance indicates that it's a strict liability crime. And 4, where the offense carries a small penalty. Let us look at each of the category as emerged from the case of Gammon. Where the crime is regulatory as opposed to true crime, the presumption of mens rea gives way to a finding of strict liability. Conversely, where there is a true crime, the presumption of mens rea prevails. And this could be seen in the case of Sweet and Parsley of 1970, where it was held that the offense in question was a true crime and therefore mens rea was required. Examples of regulatory offenses include health and safety regulations, example, pollution, sale of unfit meat. As the case of Callow and Tillstone demonstrated, and this point was also demonstrated in the case of Alpha Cell and Woodward. There was a general school of thought that strict liability applied in relation to age, and that it was no defense if a person held a reasonable belief that the person was over the specified age. So that would be probably in cases of sexual offenses or alcohol offenses, etc. However, it was later held that this was not the case, because that presumption did not survive in the case of Sweet and Parsley. The second point that came out of the case of Gammon is where a crime is of social concern. So where a crime is one of social concern, then the presumption of mens rea may be rebutted. This is based on the assumption that strict liability imposes higher standards of care and provides greater level of protection to the public. Examples of offenses of social concern would include driving offenses, as was demonstrated in the case of the Queen and Williams of 2011, and health and safety regulations, and we see that in the case of Callow and Tillstone, previously mentioned. 3, where the wording of the act or the ordinance indicates strict liability. So the presumption of mens rea is rebutted by an express provision in the ordinance or in the law, in the statute, excluding the requirement of mens rea. So where the ordinance specifically and categorically states that this offense does not require mens rea to be proven, it is clear that it is a strict liability offence. However, where the statute is silent as to the requirement, the general presumption remains. However, the court may look at other offences created under the same ordinance. If the other offences expressly require mens rea, the court may well take the view that the omission to refer to such a requirement was deliberate and that Parliament intended to create an offence of strict liability. This approach was taken in the case of PSGB and Stockwayne Limited in 1986, and in the case of Kundi and Likuka in 1884. However, a different approach was taken in the case of Sherers and the Rupsin of 1985, in which the court was considering the same statute which applied in the case of Kundi. 4. Where the offence carries a small penalty. So generally, where an offence carries a small penalty, this would indicate that it is not a true crime and is therefore one of strict liability. For example, in the case of Williams, 2011, the offence of causing death by driving without a license was considered to be one of strict liability, as the penalty was a maximum of 2 years imprisonment, whereas the offence of causing death by recklessness or by reckless driving carried a maximum sentence of 14 years. So the court made a distinction by saying causing death by driving without a license, because it only carried a maximum penalty of 2 years, as opposed to causing death by reckless driving, which carried a maximum of 14 years, that mens rea was required in the offense of reckless driving, which causes death. But in the case of driving and causing death without a license, because the penalty was so small, that was a strict liability offense. However, the mere fact that an offense carries a heavy penalty does not mean that it is one requiring the mens rea. And this was demonstrated in the case of the Queen and Prince and the case of the Queen and Howells, that an offense could carry a very serious penalty, but yet it could be a strict liability offense. Now, there are arguments both for and against strict liability offenses. Some of the arguments in favor of strict liability offenses are that, 1, it protects the public, that it raises the standards of health and safety. 2, that it promotes enforcement of the law, that it creates a deterrent, and that it makes it easier for law enforcement to administer the law. The arguments against strict liability offenses are that, 1, it creates injustice, because a person may be liable where they are not at fault, where they have exercised all reasonable care, and it is argued that this could offend natural justice. Secondly, it is argued that strict liability offences does not necessarily act as a deterrent, because in order for something or that offense or those offenses to act as deterrent, that a person must have knowledge that what they are doing is wrong, so that they're able to take steps to prevent it. Also, it is argued that there could be a stigma created because a person could be convicted of a criminal offense, which could have detrimental effects on their lives and their livelihood, etc. Now, wherever you may fall in this argument, the fact is that strict liability offenses has been here for a long time, and it appears that they are here to stay. This is where I will leave it for today. If you have any questions, please leave it in the comment section below, and I will try my best to answer. Thank you for watching, and I will see you in another episode.